record this session?
Okay, sure.
Okay. All right. So it's my time to perform, yeah? Okay, Amy, can you see my slide?
Not yet.
Huh? Still cannot see my slide. Go on. I thought I shared my slide already. Can you see my slide, Amy?
Not yet.
Okay. Disappear already my slide. Okay, I share again. Can you see my slide?
Okay. Can.
Okay, good. Okay, so I prepared my slide actually last year because I've been giving the same talk again. So this time it's supposed to be IR 2024 Okay, so there's a glitch over in my first speech anyway. Not so important. Okay, basically I'm going to cover this. Now, I can see that there's I think most of you are engineers, and I do not know how many of you are architects, although I can see one or two with AR there. So I believe majority are consultants, and I'm going to actually attune to this CIPA so that in the event that you cannot collect your consultancy fee, you can always use CIPA as a mean to claw back your fee. Okay, so listen attentively because there is a lot of salient features that you need to be aware of. Otherwise, your claim will not be successful. So today, the scope I'm going to talk about is first I'm going to give you the overview, the introduction. Then I'm going to change my hat as a claimant. That means to say I assume that I'm an architect, okay, or I'm an engineer, and my client owe me a fee, and then I'm now trying to claim back my fee. Okay, so I am the claimant. All right. Then after that, I will change my hat again and go to the other opposite side, which is the respondent. Then I change my hat again to be the adjudicator. That means to say I will adjudicate this matter, and after that, after the adjudication, you have an award one. Then what is going to do with the award? Okay. Then we also have to discuss some issue relating to CIPA, and then we come to a conclusion. So basically, we are covering all these scope. And if you have any questions, you can just write down your questions, and then I will try to answer. Okay, let's go to introduction. So what is this CIPA? Okay, CIPA is basically an act to facilitate regular and timely payment. So CIPA is not to challenge or not to claim if, let's just say, you're unhappy with his service, or we are not talking about extension of time. We are not talking about all this kind of thing. We are not talking about penalty. All right. So CIPA is mainly talking about one party are not able to claim their money. It's all money, all right? So this is an act to actually facilitate, originally to facilitate contractors' regular payment. By mean of contractor, it also means to say consultants' regular payment, okay? And then this payment has to be timely. That means to say you have discharged your work, and then you ought to be paid, all right? You can't be claiming something that your work has not finished, but in future, you get me now. So it is not timely yet. So it has to be regular and timely. Okay. And this act provides a mechanism for speedy dispute resolution. How fast is this? All right. Technically speaking, it's supposed to be within 100 days. All right. And practically speaking, it becomes 1 year. Why? The 100 days perhaps it just enable you to get your CIPA decision out from the adjudicator. But once the decision is out, all right, you will have to enforce that decision. And court may take time, and it may take another 6 months. That's why it becomes 1 year. So this is some issue we are confronting now in Malaysia. Okay. Anyway, so this is supposed to be the fastest dispute resolution through adjudication. All right. And it is very popular. In fact, it was so popular that arbitration is no longer the preferred choice. After this, they go directly to court for enforcement. Some of them don't even bother about arbitration. All right. So this is a mechanism to provide remedies to recover payment in the construction industry. What does it mean to be in the construction industry? That is another definition that we will go through after this. You know, it cannot be some other industry, for example, which is non-construction related. One example is legal services. You know, you employ your lawyer. Can we consider that as a construction industry? No. But consultancy services by architect, engineer, that is considered construction industry. So these are the salient things that we have to understand. And also to provide for connected and incidental matters. So these incidental matters is in connection to construction industry. Okay, that is what you meant. Now, who are the parties in SIPA? All right. So SIPA has become so popular that it become a verb. You know, people like, if you don't pay me, I will SIPA you. The kind of thing, you know. So sometimes we speak too fast. SIPA becomes SEPA. You know, if you don't pay, I will SEPA you. You know? That kind of thing. All right. So when we say who SEPA who or who SIPA who are these parties or who are these players in SIPA? Now, foremost, there must be a contract, right? SIPA must always start with the contract. Without the contract, there is no SIPA. Okay, and this nature of the contract cannot be just verbal. It has to be a written contract. Now, must this contract be in the form of a book? Okay, just like you know, if you have this IEM standard form of contract or the PAM standard form of contract, you know, so these are contract. It has to have a contract. It has to be written, but it doesn't mean to say it has to be like a one book. It can be comprising of partly maybe correspondence and partly reflected in your email, as long as it has to be written. Okay, so this is the meaning of a written construction contract. Okay, so with this contract, there will be two persons. Naturally, there will be a person who are not paying the other person. Okay, so that person is called a non-paying party. Okay, and then the other person is not having received their timely payment. So this person is called an unpaid party. Okay, so they have this terminology. Unpaid party means to say the person who make the claim. Non-paying party is the one who doesn't want to pay the other person. So this is a respondent. Okay, so there are two persons in this moment. Now, like I said just now, what does it mean by a contract? Okay, so if you read the SIPA Act, Section 2 tells you that it has to be a construction contract made in writing. Okay, relating to construction work carried out wholly or partly within the territory of Malaysia, including a construction contract entered into by the government. Now, this is very interesting because what do you mean by a territory of Malaysia? There is cases whereby we're talking about offshore construction, you know, the planta minyak, you know. If the offshore construction is located outside, not within the territory, and there is nothing to link that offshore platform back to the land, that is not considered to be a construction contract. If your platform is a floating one, and then you float, so you bring to one side, you must have a cable that connect it back to the mainland. So that will consider as a construction contract. So we look at this kind of situation like splitting hair, you know. Yeah, case law, very interesting, you know. So on one hand, he says cannot, and then on the other hand, he said can. So these are some of the things that is still debating, you know. So it's quite a strange thing, you know, this SIPA thing. But of everything, this is how they define what do you mean by construction contract in Malaysia. But then if you have the planta minyak that somehow it gets floated away and then connected to Brunei, then sorry, that is not a construction contract within the territory of Malaysia. It belongs to Brunei. All right, so you have to understand this point. Okay, so then the other point is this act does not apply to construction contract entered into by a natural person for any construction work. Okay, you cannot say that Abu Ali Akau, versus maybe one ABC company. It has to be between a company to another company. So this will also be a problem later on. Later I will tell you what the problem is. Okay, so this can be a problem. Another aspect is that Section 3 also tells you that this building, which is less than 4-story high, cannot be SIPA. It has to be more than 4-story high. And then there is another issue. The issue is, how do you define story? Can I consider the basement as 1 story? Okay, interesting. Yeah, all this problem goes to the court already. Okay, so the fast and easy answer is that a basement is also considered a story, because that is how we look at Uniform Building Bylaw, and that is how Uniform Building Bylaw defines story. So you can see that SIPA also relates to other statutory legislation, including Uniform Building Bylaw and so on and so forth. So the definition of story wasn't clear in SIPA, but then it was clear somewhere else, so they used that as a reference point. All right, next. The Act cannot apply in the project which is wholly intended for his occupation. For example, you can be very rich. One of the tycoons in India, his bungalow is a multi-story high building, 28-story, for example. It's more than 4-story, but then this high-rise bungalow is for his own use. It's not for commercial use, so you cannot apply SIPA. So these are the areas that SIPA cannot be applicable. Then the question is, if SIPA cannot be applicable in this kind of scenario, can other form of adjudication, like the one you have in the PAM contract, be applicable? Interesting. But so far, if that is the case, if one party says that, it can be applicable, but then the way the rules are being written and so on and so forth does not fulfill that kind of requirement that is not able to be SIPA, then that kind of adjudication is also not legal tender, or I would say that this is not allowed in law. All right. Next, we have to consider what is meant by construction contract. Okay. Now, construction work contract is a construction contract. That means to say you have a contract to say, okay, this contract, I want to build this 4-story building. So this is a construction contract. And by the same token, construction contract also cover construction consultancy contract. Example, architecture. Example, engineering. Example, maintenance. Okay. So these are all considered as consultancy contract. A law firm does not consider as a construction consultancy contract. Okay. So you have to understand, even a claim consultancy cannot be truly construed as a construction consultancy contract. So you have to be clear about this. Next, I think I have mentioned this. Maintenance contract is considered, but not legal services. Yeah. All right. Now, in other words, who are the unpaid parties? All right. The unpaid parties are generally contractors. This law is actually designed to protect contractor. Unfortunately, it has transformed into some other kind of species. So the contractor usually are the unpaid parties. Similarly, so is the subcontractors. Okay, so it covers both. Next, you cover also consultants and also sub-consultants. Who are the sub-consultants? For example, GBI Green Index consultants, for example, or Green RE professionals. So these are all considered as sub-consultants. Now, then there must be a dispute. That means to say, if there are two parties there and there's no dispute, right? what's the point of going for adjudication, right? So this is quite a no-brainer thing. So it has to be in a way that there must be a dispute. That means to say somebody is not paying somebody, or somebody has not gotten the money from somebody, okay, which is usually a dispute between the non-paying party and the unpaid party. Now, this dispute must be related to unpaid sum, okay, owed by the non-paying party to the unpaid party, which is timely. Now, what do you mean by this unpaid sum? There must be an invoice or claim. It can be an interim claim whatsoever, as long as there is a claim for your portion of your money or your fee, which is timely. That means to say, if I issue an invoice between 21 days, you have to pay me. And after 21 days, that invoice can be put as your payment claim for your adjudication purposes. Okay, not something that is have not timely or haven't what you call this, for example, work that's been done but you have not put in your invoice. These are the things cannot happen. Okay, if this thing happen, these are the amount that you can't claim because it's untimely. They're not matured yet. Okay, premature claim or premature invoice cannot be taken into consideration. All right. Now, interesting also, LAD also cannot be claimed. Okay, but LAD can be put in as a defense. Okay, so what does it mean? Later on, we will look at it. Now, when such unpaid sum arises, okay, the unpaid party can self-represented. That means to say, if in the case of architect, engineer, they can actually represent themselves. They don't have to hire a lawyer. Okay, they don't have to hire a claim consultant. Okay, now what is if you do not know how to go about this? Then you will have to go and find somebody who knows how to go about this to help you. For example, you can find lawyers to help you, or you can find claim consultant to help you. For example, I'm also doing some claim consultancy services, especially to contractors and also to consultants. So we will be helping you for a fee. Okay, in this time, it used to be just a flat, maybe a lump sum fee, but as time moves on, it appears to be the general accepted fee will be 10% of your claim, so to speak. Of course, if you go to claim consultancy, there could be more discount. Okay, so you go for claim consultant if you do not know how to mount a claim, and then if you do have your workers or your talents to help you to do a claim, then by all means you can do it yourself. Okay, so this is meaning of self-represented. Now, three parties now existed. Okay, so you have your non-paying party, your unpaid party, and of course there will be a third party which is called the AIAC. Okay, AIAC stands for Asian International Arbitration Center, whereby they are the sole custodian of SIPA. That means to say they are the only appointing body under the SIPA regime to appoint an adjudicator. Okay, so they work as an administrating the entire SIPA adjudication. So there are two parties that are fighting among themselves. They finally go to AIC to have this matter adjudicated. All right. Next, you need to submit your dispute to be adjudicated. Okay. If you have a dispute, for example, then you try to solve it. You know, go to Mama there, drink teh tarik, and then you solve the problem. That is entirely on your own. They call it negotiated resolution. Okay. But then if that things cannot happen, then you have to submit the dispute to AIAC to help you to get it resolved through adjudication. In this case, SIPA. Now we go to claimant view. All right, I changed my hat. Now let's just say I'm the professional. Didn't get my professional fee, okay, which is matured already. Yeah, for the past 6 months. I've been working in this project, did not get a single pay. All right, what do I do now to start this? I mean to say unpaid party. I need to notify the non-paying party of a payment claim. Okay, I have to write a letter. I tell, let's just say in this case, my client, not paying me. I say, Mr. Client, I have this 6-month overdue invoice, which you have not paying. You're not been paying me. Okay, I attach my invoice. Sometimes you can attach, sometimes you don't have to attach, but you just have to notify. All right, and then have to clearly state that if you don't pay me within a certain time, okay, I will take this matter to AIC for adjudication. So you have to say it out loud. You have to even say it under which section of SIPA you are serving this payment claim. So this is very important. The payment claim is the one that starts everything. You know, if you don't put in the payment claims, that means to say SIPA cannot start. You have to put in your payment claim. You do it only once. So your payment claim, what is inside a payment claim, we will discuss. Okay. Now, Section 5, we always say these are the normal terminology that we use. Section 5 say that the unpaid party may serve a payment claim on the non-paying party for payment pursuant to a construction contract, right? Now, in this section also, payment claim shall be in writing. Or you cannot take a telephone call. Hey, Mutusami, you have not paid me for 6 months, you cannot do that. You have to put into a letter, you have to write. It can be an email, not an issue, but then you have to be in a written form. So you have to be in writing. And what is in the payment claim? Okay, now A, B, C, D, these are the very important items in the payment claim. Yeah. 1, the amount claim. Once you put this amount, you cannot suka hati change. You have to stick to this amount. You cannot say today I put in, you owe me 10,000 again, tomorrow 30, the next day 30, cannot do that. You have to fix. So if you put this amount, then this is the amount that you want to claim from the opposing party. Okay? And then you have to give them a due date. Please pay up before this date. Okay? Then you have to show some details, the cost of action. In the first place, there must be a construction contract that say that he has to pay this. He has to pay within 14 days when the invoice is issued, for example. So you have to put that particular clause from whatever contract that you have. Okay, and then you must clearly show that this amount is for what description of work that you have completed. Yeah, so you have to state it very clearly. This payment is for what? For consultant, it's very simple. If let's just say this payment is for upon obtaining the approval from the local authorities, you have to state it very clearly. Okay, so these are the things, and then finally a statement. Now this statement, if you are not careful, without this statement, your whole payment claim cannot use. Tak boleh pakai. Okay, you must have a statement that says that you are making this claim under this act. Itu saja, okay? If you don't put this, your whole payment claim cannot pakai. Okay, we call this a dysfunctional payment claim. All right? So this is very important, yeah? Remember, you have to put this statement. This payment claim is served for the purpose made under this act or SIPA Act. If you can quote Section 5, even better. Okay? Now, this is the example of the payment claim that we use to help our client. Example, we write to you representing who, because we are claim consultant. It's not our own fee. We help other people, so we have to tell him who are we represent. Okay, so we write to you representing who, which is an architectural firm having this address, blah blah blah, hereby serving you on behalf of a client. Okay. The payment claim made under Section 5 SIPA 201. This is the statement. This statement tells you that I am serving you this payment claim under this section of SIPA. So I already cleared that hurdle already. That means to say my payment claim can use, boleh pakai. Okay? And with a copy of Form 1. Okay, usually there was a Form 1, but whether the Form 1 is reflected in your cover letter or not, then there is another story. But usually we'll fill out the Form 1. Okay, you can get this get this from the AIC booklet. Just hold on. This is the booklet. Okay, you can get it from AIC. All right, it's free of charge. Okay. So next, you are hereby given 10 working days as provided under SIPA to pay up the amount. Give them the time when to pay up. Okay. And then by way of cash or bank check, you have to tell them by what way, bank to my account or who or what. Okay. Failing which will proceed with the recourse of SIPA 2022 accordingly. 2012, sorry, there's a mistake there. All right, so this is a letter that you issue to the non-paying party. Now, in the Form 1, you will see things like this. Okay, so you have to state there the basis for claim. What is it for? In this case, perhaps it's a final claim for professional fee. The invoice dated what? Okay, and also some unpaid reimbursable. And also there is a column whereby you have to state your contract and what is the work that is undertaken by you. Where is the site and where is the contract sum? Okay, of course you put down your payment claim, how much you want to claim from the other person. You cannot change this anymore once it's there. Okay. Then you wait for the non-paying party to respond via their payment response. Okay, you have given them a payment claim. They are supposed to 10 working days. You know what's the difference between working days and calendar days? Working days, they mean to say Saturday, Sunday tak kerja, okay? Holiday pun tak kerja, right? So these are the few things you have to. When you say 10 working days, it should be more than 10 calendar days, okay? Because if you have to compound in Saturday, Sunday, and the holidays. So thereafter that, you wait for the other party to give you a response. They call this a payment response. Usually the opponent will not issue you the payment response. They will just keep quiet. Keep quiet. Okay. So what is in the payment response? Yeah. Now, a non-paying party who admits to the payment claim served on him shall serve a payment response on the unpaid party. That means to say he must give you a response saying why he is not going to pay you. Okay. And whether he is not going to pay you for the entire amount or he's not going to pay you for a certain amount. And he recognized certain amount. That depends. Well, this is so good. So this is the payment response. Okay. So if the payment if the non-paying party who dispute the amount claimed in the payment claim, either wholly or partly shall serve a payment response in writing. It also has to be in writing, right? And you also have to give the reasons. And then it has to be served within 10 working days. Again, once within 10 working days, I must issue the payment response. More than 10 working days, that means to say, I do not intend to give you the payment response. What happens if the non-paying party fails to give you the payment response? That means to say, automatically is considered the opponent is denying all the claim they make from you. That means to say he is disputing whatever thing, everything. You claim 10,000, he will say that, oh no, I don't owe you 10,000. That's what he meant. Even if you don't actually say it out loud in the payment response, okay? Like I say, usually the non-paying party will just keep quiet. Diam keladi. Diam ubi, sorry. Diam ubi. Okay? You will not say anything. That means to say it dispute everything, okay? Now, so if he dispute everything, that means to say either party have the right to actually refer the matter or refer the dispute to adjudication. Okay, usually the unpaid party, okay, will do this. Okay, he will exercise his right to actually refer this matter to adjudication. How is he going to do that? Okay, after the expiry date of the serve payment response, and also the thing, he can serve the what you call the the notice for adjudication. But you must remember, once you serve the payment claim, there is the nature of the dispute it falls under a limitation act. That means to say between 6 years you must take action. That means to say validity of the payment claim itself can be within the 6 years. All right. So that for Sabah and Sarawak, of course, it falls under different jurisdiction. This is just for knowledge. Okay, so initiation of the adjudication. Once that happens, you serve a written notice of adjudication. So a notice of the starting point of the adjudication, even though the adjudicator has not come into the picture yet. So you're giving a notice to him saying, I'm going to start this adjudication. Okay. So upon receipt of this notice, the adjudicator shall be appointed in the manner described in section 21. Okay, so what is in section 21? We discussed later. The one is the role of the AIC to do it. The role of me now being the unpaid person is actually to serve a notice to the opposite party saying that I hereby give you a notice of adjudication. Okay, so again, party can be self-represented or you can get a consultant to help him on this matter. Now, when a notice is served, the parties are liberty to agree on the adjudicator. For example, I happen to know this person by the name of Mutu. I know he's an adjudicator. I told the other party, hey, let's get Mutu to be our adjudicator. All right. So the other party may agree. And we say, okay, I also know Mutu. Okay, I think he's a very fair-minded person. We will get him appointed as adjudicator. So both parties will take Mutu's name and submit to AIC and tell AIC both parties agree to nominate Mutu to be the adjudicator. Okay, this can happen, but I don't think it ever happened this far. Usually one party suggested this name and the other party will say, oh, forget about it. I'm not going to agree with you. We will just let the director of AIC to appoint. Okay, so usually this is the situation. Now, okay, there are cases happens that one party would skip this step. That means to say you will not actually go and suggest or nominate a person name for the agreement of the other party. Okay, they just will, maybe they will write to AIC saying that the party did not come to agreement on the appointing or the nominating of a person to be our preferred adjudicator. We will leave this to AIC for appointment. So in this case, this matter was brought to court, and the argument from one party is that suggestion or nominating an adjudicator is something like a condition precedent. That means only if both parties fails, then only we ask the AIC to appoint. So in that particular case, the court says that although it sounds to be like that, but then this is not mandatory. It never says in the act that this is a condition precedent. Therefore, parties can automatically go and ask the AIC for appointment. Well, there is already a legal authority on this. So therefore, a lot of people just skip this step and then just ask AIC to do the appointment. Okay, so if both parties disagree with the nominated by one party, then the claimant can request the director of AIC for appointment. Now you can see before the adjudicator come into the picture, the term that they use between these two parties is still unpaid party and non-paying party. Only when the adjudicator is in the picture, then the term change. The term we'll call claimant and respondent. Okay. So now claimant can request the director of AIC for appointment, and the claimant will notify AIC to register the matter. All right. So first thing before the claimant will ask AIC to register this matter. Then the AIC will assign a spatial registration number, case case number, okay, and the fee is 265 ringgit. Okay, this is a flat fee lah, okay, standard fee. Okay, then the AIC will check the matter to be adjudicated. The AIC will technically have to check whether the dispute is adjudicatable or not. Okay. For example, 4-story building, for example, not to the wholly use of the one person. Okay. So it's not by individual. So these are the things that the AIC will check through. So if there is there's a reasonable case, or the case can be SIPA, then only they will confirm the registration. Okay. Thereafter, you will proceed, or the non-paying party will proceed to request AIC to appoint the adjudicator, and you have to pay an appointing fee. This appointing fee is also a flat fee, 424 ringgit. Okay. Of course, I think there is a change because of the SST. Last time was 6%, now become 8%. So the cost is higher now. I have not changed this item here. Now, after that, AIC will proceed to appoint an adjudicator for the matter. Thereafter, adjudicator will communicate to the parties on its terms of appointment. All right. So the AIC will choose one, and then will inform the party. You will check the adjudicator whether has he been conflicted or not. Okay. And now, after the name of the adjudicator has been appointed by AIC to preside over your case, you will have to negotiate your fee with the adjudicator. This is nothing to do with AIC. Okay, the adjudicator, they have got two sets of scale of fee. One is called the recommended scale of fee. The other one is called a standard scale of fee. The standard scale of fee is much lower than the recommended. Okay, usually the adjudicator will send in their fee proposal, all right, and their term of appointment. In there, the what you call the adjudicator will suggest to you he may prefer the appointment based on the recommended fee. Okay, so this is what the situation is. Okay, this letter that I shows in this slide is actually a letter that will issue to the respective party. In this letter, he will notify, saying that the AIC has contacted him, and then let him from this date to actually sort out his appointment. Okay, so these are the things that is usually there. Then he will also give you his term of appointment, and then the first item in the term of appointment usually is his fee lah. So this example here will shows you that the adjudicator is suggesting that he should be appointed based on the recommended fee. Okay. Then the rest of the thing is basically how to exchange document and whatnot. Okay, so these are the standard. These are quite standard term of appointment. Okay, then in response, once the unpaid party receive this, okay, or the parties, both parties receive this, then either party write back to the adjudicator to confirm his appointment. But then the terms of the appointment can sometimes change. For example, you may not agree to his recommended fee. Okay, perhaps your dispute quantum is quite large. So you will just say that, okay, I don't quite agree with a recommended fee, but can you accept the standard fee? That is what usually it has. But then, if you are adjudicator, if the party did not give you a recommended fee, that you have the right to reject everything. But then sometimes you will say, okay lah. If the other side coming from claim consultant, he will say, oh, when I decide on the quantum of fee, party to party cost, I will deduct your fee as well. This can happen, sometimes. So in this case example, it says that okay, Mr. Adjudicator, can we humbly ask you to accept the standard fee, all right? Then the rest of the term, the standard terms of appointment, the means of communication, are all very standard, okay? So usually the contention is always on the adjudicator fee. Okay, then after that, after they have received the acceptance from the parties, usually from one party, the other party will remain very quiet, assuming this is the case, okay? The adjudicator will issue the first direction, usually called direction number 1. And in this direction number 1, it will state very clearly the fee. In this case, since the other party disagree, if you see the recommended fee has to be agreed by both parties, okay? Either one party quiet or either one party disagree, then the recommended fee cannot work. You have to automatically go to the standard fee. Okay, so in this case, the standard fee is applied. And the rest of the item that in the procedural number